All right, ladies and gentlemen, tomorrow morning is the day that we have been waiting for. Rkelly is going to get sentenced on his federal charges out of the Eastern District of New York. I am really excited to see what is going to happen because so much has happened since the trial ended last year. And yeah, there's so much to expect. It's sentencing is tomorrow morning at 10:30, and one thing that I'm really wanting to see is the judge's behavior and patience. So in the actual trial, she was very patient with Rkelly's lawyers, especially like when they were messing up. She was more patient than any judge I've ever seen, and a judge has to be patient in a trial because a jury is there and you don't want to affect the jury. So she was really patient, but tomorrow there's no jury. There is nothing for her to hold back on. So I'm really excited to see if she's going to really just unleash on him and his team, or if she's going to have that same patience that she's had before. I kind of think she's going to unleash, and I'll tell you why in a minute. Now, what happens at sentencing is the first thing is you have to deal with the objections to the pre-sentencing report. The pre-sentencing report is sealed. That's standard in all federal cases, and so are the objections. So first things is you argue and present evidence about the objections. Because Mr. Kelly went to trial and lost, I definitely know that there are going to be several different objections that will be presented that may take some time. A standard sentencing in a case like with the plea agreement may take about 30 to 45 minutes, but I think this one may take longer, especially considering the length of the trial and all of the evidence that was presented and all of the things that have been filed post-trial. So after the objection to the pre-sentencing report, the judge essentially rules on those objections right then. And from there, she lets you know what the final punishment range is, what the final offense level is, and what the final criminal history level is. And he shouldn't have any criminal history points because he has no criminal history. So at this point, it will just be arguing about the offense level and if there were any enhancements that were placed on him from the pre-sentencing report. So from there, the government does victim impact statements. So victims can come and talk about whatever they want to talk about, addressing him, addressing the court about his behavior, how his behavior affected them, affected others, so on and so forth. Mr. Kelly can also have people speak on his behalf. Each judge does something different. So some judges will say you can only have 3 people speak on your behalf. Some judges let you have more. And some judges even put like a time limit on the amount of time that your people can speak. Rkelly can speak on his own behalf if he chooses to. He definitely does not have to. And I could see how it could go wrong for him if he does, because at that point the judge could also ask him questions, which could derail so many different things that he has going as far as like appeal. So after he does or does not make a statement, then there's argument from the government and his counsel about why he should receive whatever sentence they are requesting, and then the judge gives her sentence. She also then gives him instructions about any term of supervised release after he's released from prison, and how long he's on supervised release, if he has to have any conditions such as sex offender registration, so on and so forth. Now, I know that the government was originally asking for 25 years for his sentence, but they are now asking for more than 25 years because of things that were in his mitigation report. So the government is essentially saying that, hey, judge, we initially asked for 25 years, but in his mitigation report, he's denying so many things. He's denying so much of the evidence, so you should not give him a lenient sentence on any level. And I'm pretty sure his attorneys are going to argue against that. The mitigation report, it had some good things in it, but it admitted certain things that they tried to overcome in trial. One of the things that stands out to me is that in the mitigation report, the doctor admits that Rkelly has herpes, where if you guys recall, like one of my first days watching the trial, Rkelly's then attorney, I think her name was Nicole, was asking his personal doctor about different types of herpes and so on and so forth, and like kind of insinuating that he may not have had herpes, but yet they admitted in this report. So I think that if anything, the report kind of like comes and bites him in his ass a little bit. Like I said, it had a lot of great things. I think that his attorneys definitely should have reviewed it before submitting it, because these were people that were hired by his team, so they definitely did not have to use the report. Like the doctor could have created the report and they could have said, you know what, we're not going to use it. They didn't have to. And they could have just kept it, not released it, and that would have been what it was. But instead, they decided to use it, and now it has pissed the government off. And like I said, that may come back and bite him in his ass, especially because the report went into so much detail, and it went into so much detail about things that came up in trial, and knowing that 9 times out of 10, there's going to be an appeal. Those are things that me as an attorney, I would have instructed my client not to speak about, or I would have asked the doctor not to ask about, so that we wouldn't even be in this place of a gray area and trying to determine whether or not the judge would potentially be upset by those things. So as you guys know, today in the Southern District of New York, Ghislaine Maxwell was sentenced to 20 years in federal prison for her role in the Jeffrey Epstein situation. So I'm definitely curious to see how Rkelly is going to come out on tomorrow. Now, I know that there were post-trial motions. Those motions, Rule 29 motion, a motion for acquittal, and then a Rule 33 motion, a motion for new trial. Those, whenever you go to trial on a federal case and lose, it's standard for a lawyer to file those 2 motions. I've done it. And I know other lawyers have done it. And those motions are mainly done to preserve certain rights on appeal, but because certain things, if you didn't raise them in trial, you may raise them in those motions, so you have to preserve the record. Those 2 motions were denied. I completely expected that. I think in my career, I've only seen 1 Rule 29 motion granted. So those are very, very rare. One thing that I'm very, very, very curious to see, and this will take some time, is a Rule 33 motion, which is a motion for new trial, but there's another section where it says you can have a motion for new trial 3 years after a person has been convicted if there's new evidence. And apparently new evidence has come in. There is one report that one of the witnesses who testified against him made a statement and wrote him a letter saying that she felt pressured to testify. She was kind of in the bind, in addition to all of the other things that have come up about a lot of the young ladies who were witnesses against him. So I think that if his investigator and his team really, really does their job well, they should be able to get new evidence enough to file another Rule 33 motion based on new evidence and see where that gets them. And hopefully that can get him a new trial, even not on all counts, but at least some of them, which could help with so many things as far as sentencing, so on and so forth. So I'm really curious about all those things. I will definitely be up bright and early at court to make sure that I get a seat so I can give you guys all of the details about what did and did not happen. As you guys know, one of Rkelly's super fans, as the media has coined him, was arrested for making threats against the prosecutors. And I didn't read the full complaint, but I did see what they were alleging. And I don't think they have enough for the charge for this witness. I think it's really unfortunate because one of the things they talked about in the complaint was him receiving Cash App payments, the fan receiving Cash App payments from people from his YouTube, and one of them saying 30 rounds for, I think, the prosecutors, and sending Cash App. And the investigator on the case saying, or the agent saying, that he believed that the people were sending this young man money for ammunition, which is completely absurd. And it shows why it's so dangerous to have people in power or in positions of authority when they have no knowledge of culture or in context of people that they're investigating, because not even on a common sense level, but on a cultural level, we all know that that doesn't mean that these people are sending him money to buy ammunition. I think that is just completely foolish. The biggest thing is that, and I think it will be shocking to a lot of people, is to see that he will in fact get jail time. A lot of people believe that he needs serious mental health treatment, which I don't doubt that he does. But unfortunately, the United States prison system or sentencing guidelines do not provide for mental health treatment as part of a sentence or like a probation. So like at a lot of state levels, if a person needs mental health care, what happens is they can be sentenced to inpatient mental health treatment followed by probation or followed by something else. However, the federal system does not allow for that in the United States, and that's why we have the largest prison population in the world, because there is no treatment. And unfortunately, if you guys want that to change, write your Congress members. See you tomorrow.